Terrence Wilkerson had to suffer through a long legal odyssey before he knew he was out of danger.
Ooh, what a fight, what a fight. I was charged with, I believe, first-degree armed robbery, second-degree robbery, grand larceny, possession of a weapon.
But because of a controversial New York statute known as the blindfold law, Terrence's attorney was kept in the dark about a certain cell phone number.
And that phone number was the key to breaking this case open. So
how is it that the DA can withhold evidence like this?
And you have the proof that a person is innocent and still don't give that up to attorneys is not right.
It can be hard to respect the law when you take a good hard look at what's actually on the books. That's what one attorney decided to do when he created a Twitter account called Crime a Day.
To count every act that is a crime under federal law.
And there are laws about everything. Dead bees, corn husks, gesturing at a horse, even the outfit you wear.
The prosecutor decides whether your clothes are unusual or unnatural.
But this man is fighting to get a new law on the books. It's called the Child Victims Act.
It's hell when it happens to you, and you really never get over it.
Gary Greenberg, who was sexually abused as a boy, wants to change things so victims like him get more time to bring perpetrators to account.
Did you know, after age 18, New York State only allows 5 years for most survivors of childhood sexual abuse to access justice?
So many of those abusers still have access to kids.
So what's holding up passage in the state Senate?
I'm Senate Majority Leader John Flanagan.
Good laws, bad laws, laws that just don't seem to make much sense. Join us as we take a look at the law and disorder. In the first half of 2017, of the 1,612 people arraigned in 4 of the 5 boroughs, excluding Staten Island, 89% of those arrested were black or brown. Are black and brown people just more lawless? Are white people better at getting away with crime? And what does any of this have to do with ice cream? In about 3 seconds flat, I'm gonna go from a law-abiding, ooey-gooey, buttercake-loving citizen to public enemy number 32 flavors. It's against the law to put an ice cream cone in your pocket on a Sunday. Yes, this is a real law on the books, right here in New York City. But like that proverbial tree falling in the woods, if no one actually enforces it, does anyone really care? The two-headed monster of over-policing and overzealous laws does. In 1845, tenant farmers in upstate New York, upset about falling wheat prices, dressed up in disguise and attacked officers of the law, giving birth to the anti-mask law. 100 years later, that law was updated to prevent mass gatherings of 2 or more people, except in the case of masquerade parties, a stupid law that sat collecting dust on the law library shelves until 2011, when police arrested Occupy protesters for loitering and wearing masks. That law, too, is still on the books. America is a nation of laws, not of men, meaning no one person is above the law. But are the mostly men who legislate the laws that govern our lives actually doing what they were elected to do? Like protect children from individuals who would rob them of their innocence and penalize the institutions that shield perpetrators from being held accountable. Like prioritizing a speedy trial over an outmoded prosecutorial advantage that leaves defendants blindfolded. Like making my pants a haven for the dairy dessert of my choice any day of the week. So with that, let's go in.
Well, Bronx County Courthouse. This is it. I'm glad this is over with. Yes, sir. Ooh, what a fight, what a fight.
I've been a public defender at Legal Aid Society since 2002. I can't tell you how many times my clients did not believe me when I said, well, I actually don't have the evidence. Especially when—
You're my lawyer.
Right, you're my lawyer. What do you mean? That can't be right. Yeah. But because New York State's discovery laws are so antiquated, so broken, so unfair, that following the laws are actually creating really a situation of injustice.
Our state's current discovery laws were amended in 1979 to protect witnesses in criminal cases. New York is one of 10 states where prosecutors may withhold witness statements and police reports from criminal defense attorneys until the day of the trial, a period that can last years, essentially blindfolding defendants to evidence and even who's accusing them. A practice the New York State Bar Association characterized as outdated and unfair.
So I'll give you an example of a client that this affected, and that's Terrence Wilkerson. He was prosecuted in the Bronx, one of 5 people charged with robbery. And for 2 years, he went back and forth to court fighting his case. He was offered a plea. He said, no, I didn't do this.
My name is Terrence Wilkerson. Born in New York, raised in the Bronx. Currently still reside in the Bronx, South Bronx area. You know, that's where the crime happened at, I suppose. This is where it happened at this grocery store over here. But yeah, I remember being in my brother-in-law's apartment. You know, we was hanging out. So I said, let me run to the store. So I went outside to go to the store, but the store was closed. It was just a window area where the window revolved. So I remember standing there, but I felt like a lot of crowd was behind me. So I turned around and it was a bunch of police. I realized it was police there. So I said to myself, nothing to do with me, let me get back in the house. So I skipped up the stairs and got back in my building. I think it was like 5-6 minutes later, the door kicked in. Just boom, there's a boom. I lift my head up. And it's an officer come right in, and he says, what's your name? And I says, for what? What are you even doing in here? And he says, okay. And he come towards me and grab me by my arm and bring me outside to the front of the stoop of my building. The next thing you know, I was preparing to go to court. I was charged with, I believe, 1st-degree armed robbery, 2nd-degree robbery, grand larceny, possession of a weapon.
Mr. Wilkerson was arrested May 13th, 2015. We received this document when we got sent out to trial in September of 2016. In this document, it says that the complaining witness noticed that there was a phone number on the phone that had been taken from him by the real perpetrators.
The prosecution thought its best evidence was a number dialed from the cell phone stolen from the complaining witness at the bodega. The problem, as records would show, was when the calls to that number had occurred.
We were able to figure out that the phone number belonged to an escort, and that escort was advertising on Backpage. And we were able to get all of the documentation as to that to show that this complaining witness knew whose phone number that belonged to. This complaining witness had called that phone number previously. This complaining witness had called other escorts previously. And since he was robbed by this person, he happened to keep calling that number. More than, say, I think 32 times he called that number in just the month after he says he was robbed.
Wow. The evidence that was withheld A phone number. A phone number. They withheld this for a year and a half. They've been had this, a phone number that proves that it wasn't me. It was someone else, or it wasn't even anyone. But a whole year and a half later, that's when they decided to give up a phone number. It make me feel like my life don't matter, my opinion don't matter, my innocence don't matter, and you have the proof that a person is innocent and still don't give that up to attorneys is not right.
We were able to investigate this, and thank goodness, because we came back with a not guilty, not guilty, not guilty. And the jury loved Terrence. They stayed afterwards. They all waited for him. They all wanted their picture taken with him. They hugged him. All of these people who were so, I think, incensed by what happened here, but also just so moved by somebody standing up and saying, I didn't do this.
Going through the process, you know, yeah, that was very hard for me and my family. Going back and forth, up and down these blocks, back and forth to court. That was very hard.
So looking at New York State, I saw a number that 98% of the felony convictions that happen are based not on trial, but people taking the plea. That's right. If we were to have this open discovery process, what do you imagine that number would look like?
It would certainly go down. The difference is they're going to plead guilty knowing that the evidence might have been stacked against them, that the deal that was put on the table in relation to the evidence against them was fair. And so it's a fairer knowing process, whereas right now, you're blindfolded.
So cast a villain for us. Who's the enemy of reform standing at the State House door saying no?
So, you know, discovery reform, bail reform, and speedy trial reform were in the budget package that the governor put forth. The Senate didn't even come to the table, didn't include any of that in the one house. We're hoping that that will change now during legislative session.
Until that happens, what's the real human cost?
It's injustice. Every single moment we don't do this is another moment somebody's taking a plea blindfolded.
If you thought the law against the ice cream cone in my pocket was ridiculous, and it is, take a look at these.
People who have followed Crime a Day have accused me of being a bot. Never a Russian bot, but a bot. People have accused me of being a
computer algorithm.
Disgruntled prosecutor. They don't know who I am, but I promise I'm human. For the last 8 years, I've been practicing as a criminal defense attorney in Connecticut. In the 1980s, the Department of Justice set out to count how many federal crimes there were. How many crimes are there? The Department of Justice put a team on it and ultimately had to abandon the project with nothing more than an estimate. Crime a Day tries to do what the DOJ didn't do, which is to count every act that is a crime under federal law. During the day, I represent clients in criminal matters, but at night, when the day's over, I spend hours reading the Code of Federal Regulations, reading statutes, reading legislative history. That process involves hours of analysis. Ultimately, it produces 140 characters of a tweet with a silly-sounding crime. There are other laws that are still on the books from hundreds of years ago that were inspired by uniquely New York things. What I found was, most of the time, these laws grow out of a legitimate need or a legitimate problem, but have been drafted in such a way that they rope in conduct which really shouldn't be criminal. It's a crime to bring an unshucked ear of corn out of New York into any other state. One of the things every first-year law student learns is that every crime requires an actus reus, which is the act that you have to commit, and the mens rea, which is the mental state you have to have when you commit the act. Mens rea asks, what was in your head when you killed that other person? Did you do it on purpose? Did you do it in self-defense? Did you do it by accident? Theoretically, it can mean that you are or are not a criminal. If there are hundreds of thousands of laws, And if it doesn't matter whether you know the law or you don't know the law, you can be charged with a crime that you had no reason to believe existed. In 1986, a jazz musician named Kirk Lightsey was trying to get on the subway. His hand came too close to a passenger's purse, and he was charged with the jostling statute, to put your hand on somebody's purse or too close to their purse. And that creates a problem. While we trust law enforcement officers to exercise the right decisions, if a law enforcement officer were to choose to target an individual for an improper reason, they could pick the defendant first and the crime second. Some people that have followed crime a day have raised the prospect that crime a day itself might be a crime. I haven't found any statute that prohibits listing the statutes that Congress itself has passed or the regulations that regulators have issued. A local example of this explosion of criminal laws is one of the older penal laws in New York prohibits wearing unusual or unnatural attire. What does that mean? Attire has been construed to mean a man wearing women's clothing. A prosecutor decides whether your clothes are unusual or unnatural. That creates a little bit of fear in people to realize that just by living, I could potentially be charged with a crime. Legislative inertia to not repeal old statutes is fine as long as we assume that those statutes are not going to be used to prosecute people because they're vague. It's a crime to board a ship that's about to arrive but hasn't arrived at shore yet. It has to do with a time in history when people were essentially being kidnapped off ships. That crime was dusted off and used fairly recently to prosecute Greenpeace activists because they were trying to unfurl a banner on a ship. I don't think that they imagined that they were going to be charged under federal law for early boarding of a ship. That risk that a person could be prosecuted for a political reason, a racial reason, a religious reason, it's too great of a risk for us to not address it. And that's why we shouldn't leave all of these criminal possibilities on the table. And we should start paring them back. I don't think it's an exaggeration to say that everybody has committed a federal crime, because so many of them don't require an evil state of mind when you're doing them. Things like throwing balls at somebody's head while they're in public to humiliate them. Supposedly, carnival workers were getting mistreated. In a national park, it's a federal crime to make an unreasonable gesture to a passing horse. That raises questions. Unreasonable to who? The horse? Should it be a crime? I don't know, but it is. The future of crime a day is to keep doing exactly what it's been doing. I think as long as it's still making me laugh and be scared all at the same time, then I'm the right person to keep doing it. And based on conservative estimates, I have a couple hundred years left to go.
To be sure, there are some mystifying laws on the books. Laws that may very well have addressed genuine societal concerns, but are now the relics of bygone eras. You can learn a lot about a culture from their laws and just who they choose to protect.
You know what drives me? That doesn't happen to anybody else. It's hell when it happens to you. And it takes you a long time to get over it, and a lot of therapy, and you really never get over it.
50 years ago, Gary Greenberg suffered a brutal attack at the hands of a serial child rapist, making him one of the estimated 42 million adult survivors of childhood sexual abuse in the United States.
It was a couple months after that I was abused. My mother saw that I was not acting right and asked what was wrong. She got out of me what happened. My parents went to the police and they were told that, forget about it, just go on your way.
5 decades later, attitudes towards victims have evolved, but the laws in New York State have not.
And the average predator will abuse 100 kids in their lifetime. The abuser who abused me, the predator, 300 kids that he abused in 30, 40 years. And to be honest with you, Brian, not one damn thing has changed. There's abuse going on just as there was abuse then. And shame on this legislature and governor for not doing something about it.
Did you know that more than 40,000 children are sexually abused each year in this state? Did you know, after age 18, New York State only allows 5 years for most survivors of childhood sexual abuse to access justice?
In New York State, a victim's 23rd birthday marks the end of their ability to file a civil suit or make a criminal charge against their abuser, one of the most restrictive statutes of limitations in the country. A proposal known as the Child Victims Act would change that. Under the act, victims could file civil suits until age 50 and see criminal charges until age 28. Since 2006, New York's Democrat-controlled Assembly has repeatedly passed a version of the Child Victims Act. And for the last 12 years, the bill has died in the Republican-led Senate. Senator Brad Hoylman is the ranking Democrat on the New York State Senate Judiciary Committee and the prime sponsor of the Child Victims Act.
Nobody comes forward to take responsibility to oppose this legislation. It's just blocked. The Senate had never voted on anything like this in its history. So it is a sad state of affairs in Albany, but I hate to say this, but it's true. It's business as usual.
Gary Greenberg has taken the unusual step of creating a political action committee to advocate for the act by challenging lawmakers at the polls.
You've actually gotten politically active in funding folks to that end.
Yes, I formed a PAC, Fighting for Children, and I put up $100,000 of my own money.
We don't often hear about political action committees for survivors.
No, it's the first of its kind. It's a revolutionary approach on the politicians' field, and we're going to go after them with and support candidates of our own.
Who's the bad guy? If you were at a protest, is there one picture that we could put on a picket sign and say, this is the enemy of reform, this is the person who's protecting predators?
Oh, certainly the senators that have continually voted against the act, like Senator Bill Larkin and Senator Kemp Hammond and the Majority Leader John Flanagan. These individuals have continually not supported victims, and John Flanagan killed the bill this last June. He's the majority leader and he wouldn't let it come out onto the floor.
Hi, I'm Senate Majority Leader John Flanagan.
John Flanagan is a Republican senator representing Suffolk County in Long Island, and the Senate Majority Leader elected by legislators as the main spokesperson for the party to ensure members don't vote against the party consensus.
So if you had John Flanagan right here as close as I am to you right now, what would that conversation be? You know that he is not against protecting victims,
right,
but he's done some things that are clogging up the works.
Right. I would, want to know why. The streets are unsafer because John Flanagan and the Republican majority would not bring this bill to the floor, so I'd ask him that. Why is he allowing these predators to stay on the streets and keeping kids' safety at risk?
BRIC TV made several requests to Senator Flanagan for an interview or a statement. None of those requests were fulfilled.
My colleagues who oppose this should be smoked out, should be shamed, should have a spotlight shone upon them, and should be asked by their constituents why they oppose giving survivors their chance at justice.
Flanagan and the Republican senators have an ally in their opposition to the bill, in the form of the Catholic Conference. The main point of contention is what's come to be known as the look back, a one-year window allowing victims to file civil lawsuits for alleged abuse, regardless of when the abuse took place. A fixture in 8 other states, including California, it's a proposal opposed by the Catholic Conference of New York, who issued this statement to going in. We support the complete elimination of the criminal statute of limitations for cases of child sexual abuse, as well as significant lengthening of the civil statute. The one area of disagreement is the concept of an unlimited retroactive window that would allow new lawsuits for cases from decades ago. We believe such an action could have serious unintended consequences for organizations that provide essential services to communities and would do nothing to protect children from abuse today.
Are you afraid of what that could potentially do to members in your district who happen to belong to churches?
There is a justice system, and I believe in it. And just because we're lifting the statute of limitations doesn't mean that everyone's going to be found guilty or innocent. So many of those abusers still have access to kids. And by allowing the 1-year look back, we actually provide a mechanism for the public to know who these abusers are. We have a process, and there are laws of evidence that make certain it works well and protects the innocent.
The Catholic Church has funded a compensation program for victims of sex abuse. And though they won't say how much has been paid out, 118 abuse victims have accepted compensation, with the condition that they take no legal action against the Archdiocese.
But the hell with all those other people, you know, they do not support the 1-year look back particularly.
That's not a compromised position for you.
No way.
I
I wouldn't take anything without the 1-year look back.
You got $100,000 in seed money versus their millions of dollars worth of influence and lobbying. How much is it worth to the Catholic Church to keep people like you locked out of the floor to vote on stuff?
The accountability is on them to acknowledge and to let this law pass so the victims of priests, the victims of rabbis, the victims of anybody can, the last 30, 40, 50 years can go in and they can get what they need to get as victims of child sexual abuse, and that's accountability of their perpetrator predator.
76% of New Yorkers polled support the passage of the Child Victims Act. But the bill has never been brought to the floor of the Republican-led state Senate for a vote. How did protecting children from sexual abuse become a partisan issue? Survivors will continue to advocate for accountability and pray for answers. Thanks for going in with us as we chronicle the little law and disorder. Keep those ice cream cones out of your pocket and check out past episodes of Going In at youtube.com/BRIC TV. Bye now.